Hello and welcome to IITV, Independence Institute Television. I'm your host, Justin Longo. With me in the studio is Professor Rob Natelson. Today we're going to be talking about the 14th Amendment. Why is that? Well, Donald Trump has been talking a lot about the term anchor baby, and anchor baby is a pejorative used against illegal immigrants who have kids in the United States who then the kid is an American citizen by birthright. This is all covered under the 14th Amendment. You have both sides of the issue saying that their side is clearly correct, but our good professor here says it's not clear at all. And so in order to illustrate this point, we're going to have him give both sides of the issue and talk about some of the evidence in the history of the founding era to describe why this is not such a clear case. So, Rob, you've been hearing a lot about this issue from both sides. Both sides seem to be very confident in what they're saying. You are a constitutional scholar. You've been studying this stuff for years. You're a professor. It's not clear to you. So why is that?
Well, Justin, I've been a little bit frustrated about it because the statements on it have been so categorical. A few years ago, Time magazine simply said that if somebody has been born here, then he's a citizen, end of story. Well, the problem with that is that the 14th Amendment, which governs this area, requires that someone, in order to be a citizen under the 14th Amendment, be born here and subject to the jurisdiction of the United States. So there's this additional requirement that Time magazine didn't even mention. Some advocates, particularly on the conservative side, are going around the country saying, actually, it's very clear that the children of foreigners illegally here are not citizens. And I think they've gotten many conservatives who are opponents of birthright citizenship kind of geared up and maybe a little misled. And so I wrote a series of 3 columns which appear at constitution.i2i.org, which describe really how difficult a case this is.
I really like the idea of you giving the best case for both sides.
Mm-hmm.
So which side do you want to start off with to give us your best argument for that side being clear? And then so we can see after you give both of these cases, well, it's probably not so clear.
Well, let's give the example of, let's start with the argument for birthright citizenship.
Okay.
For the idea that if someone is in this country illegally, his or her child is, notwithstanding the illegality, a citizen if born within our boundaries. In 2 separate cases, the United States Supreme Court has ruled, and both these cases were 19th century cases, that the term subject to the jurisdiction thereof imports within the Constitution the Anglo-American concept of allegiance. Allegiance is a word for the relationship that exists between someone who lives in a country or is present in a country and the sovereign. The sovereign has an obligation to give protection to that person, and by reason of that protection, that person has allegiance. Allegiance applies obviously to somebody who's a citizen of the country, but and that's called natural allegiance. But there's another kind of allegiance called local allegiance that applies if you happen to be a guest of the country. And under the doctrine of allegiance, as the British understood it, and as it was imported into the Constitution according to the Supreme Court, someone who is born in this country of parents who are merely sojourning here is in fact a natural-born citizen. These folks might also point out that at the time the 14th Amendment was adopted, there were a large number of people in this country who were foreigners, and some of whom were the children of people who were illegal foreigners. Mm-hmm. And by that I mean the newly freed slaves.
Yep.
One purpose of the 14th Amendment, a principal purpose, was to extend citizenship to the newly freed slaves. If the 14th Amendment did not cover foreigners, then it would have failed in its purpose of extending citizenship to newly freed slaves, since under the Dred Scott decision of 1857, they were legally foreigners. And some of them were the children of illegal foreigners. Between the time the slave trade was abolished in 1808 and the time that the 14th Amendment was adopted in 1868, there had been an illegal slave trade going on, and some people were brought into this country illegally. There was no, of course, it wasn't their fault, but they were still here illegally. There was no suggestion by any of the people involved with the 14th Amendment that I'm aware of that those people were not covered by the 14th Amendment. Their presence was well known, and if they were accepted, then it would seem that if they were not accepted, then they would seem to be covered. There are some little excerpts cited sometimes by opponents of birthright citizenship. Those excerpts come from the congressional debate by the people who framed the amendment. But those excerpts, when you examine them in context, are ambiguous. And furthermore, what the people who framed the amendment said is not as probative as those who as what was said by those who ratified the amendment. And thus far, the opponents of birthright citizenship, to my knowledge, have not come up with any evidence from the ratifying state legislatures suggesting that they thought, subject to the jurisdiction thereof, excluded people who were here illegally. So those are some of the arguments that could be raised in favor of birthright citizenship, and they are not insignificant, and you simply can't blow them away by quoting a few excerpts from the framers of the 14th Amendment.
So it's a pretty strong case for the children of illegal immigrants to be natural-born citizens. Mm-hmm. Just like if two slaves brought here, ripped from Africa, brought here, had a kid, that kid would be an American citizen, right? Two right. Slaves, right? So what is the argument? What's the strongest case for the other side? So we can see how that goes.
Well, let me say what the case should not be. And what the case should not be is the case that it is in fact being made by many of the opponents of birthright citizenship. For example, they are arguing that the leading Supreme Court case on this issue, the case of Wong Kim Ark, which was decided in 1898, that should be overruled. That case declared that the children of foreigners who are here legally are natural-born citizens if those children were born within the country. They also, as I mentioned, rely upon certain little clips from the debate among the framers, but they have not yet done what they need to do, and that is to go to the ratification debates in the state legislatures and see what they can find there.
Wait, just so I can wrap my head around this, there are people today that think that the children of legal immigrants would not be natural-born citizens.
That's right. In fact, some very respectable legal scholars are arguing that. And can you imagine how that would upset expectations? My own father, for example, would not have been a natural-born citizen because although he was born in this country, his father, under the rules of allegiance, citizenship follows the father usually, his father was still a citizen of what was then Lithuania. So, yeah, it would upset a lot of expectations.
So what's the best case that these opponents have?
Okay, what the opponents need to do, besides investigating the ratification record, is instead of trying to argue for overturning existing Supreme Court precedent, they need to build upon existing Supreme Court precedent. That precedent tells us that the term subject to the jurisdiction thereof incorporates the Anglo-American doctrine of allegiance. And as I mentioned a minute ago, as a general rule, allegiance means that if you're born in this country, you're in allegiance and are therefore a citizen. However, opponents of birthright citizenship can point out that there are some important exceptions to that. For example, the child of a foreign diplomat born in this country is not a natural-born citizen.
Interesting.
So if the ambassador from Great Britain and his wife have a child in this country while they're here representing their country, that person remains a subject of Great Britain, not a citizen of the United States.
So foreign diplomats having kids here.
That's right.
Doesn't.
Because foreign diplomats carry their law with them. Mm-hmm. They're not subject to the jurisdiction. And that particular exemption was mentioned, at least in the debate among the framers of the 14th Amendment. Whether it was mentioned in the ratifying legislatures, we don't know yet. Secondly, it's acknowledged that there's an exception if the child of a foreign invader is born in a particular country. Because let's say, for example, when the British invaded Maryland during the War of 1812, say a British officer had brought his wife with him, and she had a child born in Maryland. That child would not be a native-born citizen, natural-born citizen, because that child was not really born under the protection of the United States. The reciprocal of allegiance is protection. You need protection in order to have allegiance. And then in the late 19th century, the Supreme Court recognized a third exception, which was also recognized by the framers of the 14th Amendment, and that is tribal Indians, especially tribal Indians in what were then the American territories. In those days, that was before we had a law, which we now have on the books. We have a statute which says that if you're born within a tribe in America, you are an American citizen. But you're an American citizen by reason of a statute, not by reason of the 14th Amendment. The Supreme Court decided that a tribal Indian born in the protection of his tribe was not a citizen because that person was not really subject to the American courts. The United States didn't really try to govern the tribes as to their internal affairs in 1868 when the 14th Amendment was ratified.
And they would have the allegiance towards the tribe.
They would have the allegiance toward the tribe. That's right.
Right.
That's right. They have allegiance. So you need to build on those exceptions. And one argument would be based upon the fact that allegiance is a reciprocal arrangement, protection and the duty toward the sovereign. The sovereign protects, the citizen gives the duty, or the person in allegiance gives the duty has the duty of allegiance toward the sovereign. People who come to this country in violation of our laws certainly are not evidencing any intention to throw themselves upon the protection of their sovereign. There's a famous case that in 1772 in Britain, which involved an escaped slave, a slave that had been enslaved in Virginia, who came to Britain and openly threw himself on the mercy of the British court. And he was recognized as being in allegiance. That's precisely what illegal aliens are not doing. And remember that the important thing here is not what the kid says, or because at the time of birth, because the kid can't speak. What's important is what the parent's status is. The parents are not throwing themselves on the protection of the country. They're here in violation of the laws of the country, and that is a significant distinction, a difference from aliens who are legally here and who have openly agreed to honor the laws of our country. And so you can say that, allegiance is really a kind of reciprocal contract here. Usually the contract is implied. It's implied by your being born here, you're continuing to live here, or you're living here illegally. However, in a case where someone is here illegally, that person has loudly announced his or her intention not to be in allegiance to this country, and therefore should not be able to communicate birthright citizenship to his or her children.
If we've always been doing it the birthright naturalized citizen sort of way for all these years, where the children of illegal immigrants are in fact American citizens, if that's the way it's been for a long time, wouldn't the opponents have to muster a really strong, epically strong case in order to overturn these, how many years we've been doing it this particular way? I'm not saying it's the right way, but I think in the current status quo as it exists in 2015, I think that the opponent side would have to have the stronger case, not the status quo side. Right? It's
called the argument from usage, and to carry on our argument on both sides, there are arguments on both sides. Those folks who are in favor of birthright citizenship can point out that we seem to have accepted the presence of many foreigners in our country who are here illegally. Especially in recent years, we've extended benefits to them. We've extended welfare benefits. We've extended driver's licenses. We've extended preferential treatment for residents at state school tuition. And so under that circumstance, one could argue, effectively the government has agreed to these people living here, even if there are laws on the books to the contrary. The argument on the other side, however, against birthright citizenship is, number one, the Supreme Court really has never ruled that the children of people here illegally are natural-born citizens, and that's been recognized as an unsettled issue for a very long time. Secondly, one of the teachings of the two leading cases on this subject, the 19th century cases I mentioned earlier, is that no state can be, or no country can be forced to accept citizens against its will. And there has never been really an agreement to accept the children of people here illegally against, never been an agreement by the sovereign to accept them as citizens. And in fact, quite the contrary. There are laws on the books saying that the people who come in violation of our immigration laws can be deported. And so even if we have accepted some of them for purposes of residence, it doesn't follow that we've accepted them for purposes of transmitting citizenship to their children.
Do you have any final concluding thoughts on the opaqueness of this whole subject?
Yeah, I've got two. One is, this illustrates something that people interested in the Constitution should take away from this conversation that goes beyond the issue of birthright citizenship. And that is, when you're dealing with the 14th Amendment, all bets are often off. And that is because the people who drafted the 14th Amendment were not in the same level as Gouverneur Morris or James Madison or John Dickinson. These were people of much more modest abilities, and they made quite a number of mistakes. In fact, one senator during the debates in 1866 over the 14th Amendment, Reverdy Johnson of Maryland, implored his colleagues not to use ambiguous words in writing the 14th Amendment because we needed clarity in order to understand it. Unfortunately, his colleagues, in many cases and parts of the 14th Amendment, disregarded that particular appeal. And so we've been arguing about the true meaning of subject to the jurisdiction thereof for many years. We've been arguing about the true meaning of the Due Process Clause, the true meaning of the Equal Protection Clause, the Privileges and Immunities Clause, and even about the provision in Section 5 that gives Congress the power to enforce the amendment by appropriate legislation. All of those cases are constant fodder for the Supreme Court, and the Supreme Court, some of its most egregious examples of activism can be partly justified, not fully, but partly justified because of the opaqueness, as you said, of the wording of the 14th Amendment. And the second takeaway is that, this is going to have to be decided by the Supreme Court. And don't ascribe bad faith to the folks who hold a different position than you do on this issue. This is a very difficult constitutional issue. I should clarify, I don't have a dog in this fight, okay? I don't have strong feelings on this issue one way or another. I'm trying to report the law as it actually is.
Like you always do.
And it is profoundly uncertain at this time.
Any rumblings or rumors of that the Supreme Court's going to take this sometime soon?
Oh yeah, there are some cases I understand boiling up through the federal court system. The Supreme Court will ultimately have to deal with them. And how the court rules is anybody's guess. I would, if I were a betting man, given the court's prior adoption of the Anglo-American concept of allegiance, and given the strong presumption that under the rules of allegiance that someone born here is a citizen, I think probably the court will come down on behalf of birthright citizenship. But this is not a done deal, and I think both sides have a fair shot.
Where can our viewers find more information about you, what you've done, your work? Where should they go?
Well, the best place is to go to constitution.i2i.org. That's constitution dot, the letter I, the number 2, the letter I.org. I've got 3 essays and another interview on this subject, all posted there. And also for general background on the Constitution, not so much the 14th Amendment, but on the original Constitution. Take a look at my book by that name, The Original Constitution, what it actually said and meant, and that's available at Amazon.
Amazon.com. All right. Well, thank you for joining us at Independence Institute Television, IITV. Check us later for more video casts like this, and of course, more Rob Natelson. Who doesn't want that? We'll catch you next time.